Hello, everyone. Welcome to the Pulse podcast by the Power Broker Media Group. I am your host, Adrienne Reddick. Please be sure to subscribe, like, share, and leave a comment or ask a question. Thank you for joining us for today's discussion. We're here to explore how families can protect, grow, and successfully pass down land across generations, and how issues like heirs property, probate, and reverse mortgages can either support or threaten that process. Land has always been one of the most enduring paths to wealth, but keeping that land in the family and making it work for future generations requires foresight, planning, and sometimes tough conversations. Today, our expert will help us unpack all of that. Please join me in welcoming Attorney Tamara Felton-Howard. Tamara, thank you so much for joining us. Please let the audience know who you are, what organization you represent, and your area of expertise as it relates to this topic.
Sure. Well, first of all, thank you. You're certainly welcome. I'm happy to be here. I am an attorney. I practice in St. Petersburg, particularly South St. Petersburg, for over 27 years. I am primarily practicing right now in the areas of estate planning and probate. However, throughout my career, I've practiced in real estate. I have an advanced law degree in real estate development, so I've represented some local developers here. And I've also practiced in criminal defense and family law and business law. So those are my areas of expertise.
Okay. Thank you very much. So today, to begin with, I'd like for you to briefly share, why is land one of the most important and powerful tools for building generational wealth?
So land is the major asset that a lot of people possess. Even if you don't have $100,000 in the bank, most people own their home or are buying their home. And so I found that especially, in our community, you may pass away and own a home, have a bank account with some sums in it and a car, but your home is going to be your major asset, especially if you don't have a loan on it or you don't have a mortgage on your property. And so we find that the, transfer of that asset from generation to generation greatly increases the next generation's, opportunities to do whatever. And especially now in Pinellas County where we have, homes are worth so much.
Yes.
A lot of value. It has really, really been an asset. And I've seen it for many clients passing on that wealth to the next generation.
That is definitely one of the things to talk about because, yes, the prices here in St. Pete have skyrocketed. It's been amazing how much money homes are selling for here in the St. Pete and Tampa Bay area.
Absolutely.
Yeah. So let's get into some of these topics here. So first I want to talk about heirs property. And one of the biggest threats to family land is heirs property. For those who are unfamiliar, what is heirs property and why does it put families at risk of losing land?
So heir property typically refers to a form of ownership where folks own property as tenants in common. So you own an undivided interest in property. It can occur if you own an undivided interest and it's not titled so that someone would inherit the property automatically upon the death of a co-tenant. You may each own a third of the property, for example. So if one person passes away, one of the owners of the property, then their portion would then need to may need to go through probate and go to their heirs, and you're adding more people to the property. Another instance where heir property occurs is if you have someone pass away, they don't have a will. In Florida, we have an intestate law, and so it lays out exactly who inherits property. So, and I've seen it happen very often if, for example, you have a single person who's not married, no children. The property may go to their siblings, for example, some of whom may have passed away, who have children. Children have passed away, you have grandchildren. And so I've had a property, for example, that had 32 names on the property.
Wow.
So it ties it up so much to the point where, a lot of times people can't get on the same page. You may not be able to reach everyone. You may have estates that you have to open up for individuals that have passed away. And so the property, is essentially heirs property. and it can get really tangled up, and it's hard to untangle the title issues relating to that property. And so in the African American community, it's especially it can be difficult because sometimes you have property where you just allow someone to live in it. Let's say a grandmother passed away, you allow, a cousin, aunt, uncle, whatever to live in the property. Never straighten up the, title issues until it's, you have to.
Right.
And sometimes it just becomes very, very cumbersome to do that at that late date.
Wow. Yeah, that is a lot. So for those families who may already have heirs property, what are the first concrete steps they should take to stabilize ownership?
So look at, who, first of all, I would suggest going to see an attorney, because we can definitely look at who is the rightful person or persons to inherit. Sometimes, you may have someone who was married at the time they passed away. The surviving spouse has significant rights. So those issues need to be resolved. If you have children that, hopefully, you're aware of all the children and know where they're located. So I think the most important thing is getting contact information for everyone, because if I have 16 people that are entitled to inherit, I want to be able to contact them. Some people don't want to have anything to do with the property, which is fine. We can get them to sign up, some sort of waiver, but getting in contact with everyone is very important.
And then what legal tools like family agreements, partition reforms, or title clearance are most effective?
So you can certainly have a family agreement, a beneficiary agreement. It needs to be properly drafted. In many instances, when it relates to real property, you want to have that just witnessed by at least two people, and notarized. So you want to have the same sort of formalities that you would have with a deed with those agreements. So I would suggest, probably not drafting it yourself, but having a legal professional help you out with that. Beneficiary agreements are helpful when you have a property where, maybe people don't necessarily want to inherit, so they disclaim their interest. Or if, just in trying to determine, well, what do we do with this piece of property? So you have people that want to sell, some people that don't want to sell. Yeah. You may have some relatives who are living in the property. And so they, have the advantage of living there, potentially with no rent payment. But then this happens so often, others who are entitled to ownership of the property, but they're not benefiting from the property because they don't live there. So in that instance, you then would turn around and may have to open up a partition action forcing the sale of the property. So if you have an agreement where, maybe they agree to pay rent, or you agree to sell the property, what have you, then it makes it a lot easier.
I can see this getting very sticky.
Yeah, it can get very sticky.
Yeah. And possibly having some issues, family issues too, as you're trying to work through all of these things.
Yeah, probate can be very, a lot of tension, a lot of conflict. That's why I always recommend that, we look at estate planning ahead of time before someone's passed away, because if you do it properly, then you can cut down on a lot of the conflict for your family, just make it a lot easier. And make sure that who you want to inherit the property actually receives it. Because you may want, Aunt Susie to get it, but then it goes to someone else.
Correct.
It's just not, your wishes aren't followed. So I know it's a little intimidating. I mean, people don't want to think about death, and then some people believe, well, if I do my will, then that means I'm gonna die, or they have those superstitions. But it's better to get ahead of it. It really is.
Exactly. So now you brought up probate, right? So let's go into it. As you just talked about, right? A lot of people fear it. They misunderstand it. They think, yeah, if as soon as I make plans, the Lord is taking me out of here, right? But let's talk about why it's such an important part of transferring land smoothly across generations.
Yeah. So probate, they're primarily, there are two types. So you can do intestate, which means you died without a will, or testate, meaning you had a will. Very often, if you utilize an attorney, you may even be able to avoid the probate process altogether by properly structuring your assets. But if you have to go through probate, then the state of Florida, if you die without a will, determines who receives your property. So it's according to statute, and that's If you have a will, then you can control that, a lot better. So I definitely recommend, and probate is just the process of going to court to obtain a court order indicating who would receive possession of your assets, who those assets are going to be transferred to.
So what estate planning documents make the biggest difference for landowners? Is it wills, trusts, the transfer on death deeds?
So transfer on death deeds or enhanced life deeds are an extremely useful tool in the state of Florida. Not every state allows you to draft or to execute a enhanced life deed. Another name for that is ladybird deed that people may be familiar with. So what that deed allows you to do is put your property, you would continue to own your property for your life, but upon your death, it would go to your beneficiary. The enhanced life deed is very useful. Now, there are some instances where it may not be as practical. Let's say, for example, I'm a grandmother. Well, so let's say I want to leave, I want my house to be sold and I want funds to go to my children, to my grandchildren, in that instance, enhanced life deed may not be the most practical way to go about that. But if you just have a house, I just want to leave it to my kids, and it's a very, very useful tool. Also, revocable trusts are very useful in terms of avoiding probate. A lot of people come in and they ask about a trust, but depending on your estate planning goals and also the assets that you own, a trust, you may not need to draft a trust.
Okay.
Because it may just be, we can get away with doing transfer on death, instruments to avoid probate rather than drafting a whole trust. So that's a good, and then also with trusts, even though you prepare a trust, there may need to be some administration of the trust even after you pass away, which might facilitate you still hiring an attorney, or your heirs hiring an attorney, your beneficiaries hiring an attorney. So that's going to be a cost associated with that. So it's just all depends on your situation, and it's better, to come in and speak with an attorney about it to kind of get an idea of what is the best way for you to go.
Okay. All right. And then what are some common mistakes that you see families make during probate or estate planning?
So the most common mistake, I think, is not having a will. So a will does not avoid probate. A will is essentially just instructions on who should receive your property. But it's also a very useful tool. Like even if I draft a trust, we still draft a will to go along with that, because you want to make sure that you don't have a situation where your assets are passing under Florida law and it's creating a lot of heirs or different people inheriting the property where it's just very cumbersome. So wills would kind of cut down on some of that. Another, asset obviously is to, if you have a bank account, for example, naming beneficiaries on your account. Because if your bank account goes directly to a beneficiary, then you don't have to worry about probating those assets. They don't go into probate, and then the bank transfers those assets directly to whoever you name.
Okay.
So that's something to think about as well.
All right. So one other topic, the other day I got the little pamphlet in the mail, a little postcard about a reverse mortgage. Right. And reverse mortgages are often marketed as a way for seniors to access equity, but they can, I think, affect the inheritance, right?
Absolutely.
So in what situations might a reverse mortgage be helpful? And what situations might it put generational land at risk?
So there are pros and cons to a reverse mortgage. So with the reverse mortgage, when you get that mortgage, it's great because you receive, it's like a mortgage, which, you get funds, cash out, and you don't have to pay it back. It doesn't get paid back until you pass away and they sell the home. But the problem, of course, is the sale of the home. So if you're selling the home, you're not able to pass it on to the next generation. So that's something to think about. And once you pass away, then interest accrues during the course of the loan. And then once you pass away, you have, all this interest that you are going to owe over and above what you borrowed. And so your relatives would only have, if they want to keep the house, usually it's about 6 months to either get another mortgage to pay that reverse mortgage off or, sell the house. Occasionally, the reverse mortgage company will allow you to get an additional 6 months, so up to a year, but typically it's just 6 months that they have to resolve that. So I have had instances where, the family just wasn't able, no one was really able to refinance. They weren't able to sell it in enough time. Potentially you can go into foreclosure in that situation. It's a benefit if you're not trying to leave the property to the next generation, or if your heirs have the ability to pay that reverse mortgage off if you pass away.
That's definitely something to think about, because we don't typically, I think people get enamored with the amount that, oh, I can get this money now, right? Not thinking about the long term of having that burden on your family if you want to keep that home in the family.
And even during your lifetime, you have to remember that you're required to keep your house, maintain your home. So they're going to be looking, doing inspections, looking at your roof, looking at different things that may be going on with the house. And so you will be required to get those things repaired if during the life of the reverse mortgage. Yeah. And if not, you could be in default.
Are there any alternatives for seniors as opposed to doing a reverse mortgage?
Right. So you could look at doing, like a home equity loan. You speak with those. I mean, obviously you would have to pay that back. So I have to have the income to be able to pay that back. I wouldn't borrow more than, than necessary in that instance. But a lot of times your interest rate is going to be lower than with the reverse mortgage. Obviously, the advantage of the reverse mortgage is that, you don't have to pay it back during the lifetime of the loan, but you still are going to have, requirements to maintain the home, and that's going to be an expense. So that's something that, you may want to think about as well. Home equity, if let's say you go to live with, a family member, you could even rent your home out if that's something that's appealing to you for extra. You would, those are some of the options that you may have.
All right. This has been really enlightening information for us today. I really want to thank you, Tamara. I want to leave with one thing as we're closing. What's the one practical action families can take this year to strengthen generational land ownership?
So what I would do is everyone should look at the title to their home, right? Make sure that your home is properly titled, because I've had instances where, we've come back and let's say it's a married couple that bought their home. I'm going to give you an example. They bought land before they got married, and then they built a home after they got married. Well, the house was not in their name as husband and wife. They had never gotten a loan on the house, never, and that was a big disaster. So make sure everything is titled correctly. And then the second thing, again, would be to make sure you have a will. Make sure you have considered, your estate plan. Start thinking about it. Who would I want to leave things to? Take an inventory. So a lot of people think they don't own anything, but you do. If you own a home, car, you have personal property.
Right.
You may leave, your loved ones with, your furniture, your clothing, your jewelry. Those things may be sentimental to them. So really take some time to think about how you would convey your assets.
Okay. So if anyone in our audience wanted to get in contact with you or discuss more with you, how would they contact you?
So we're located in St. Petersburg, across from the main post office at 3110 First Avenue North, Suite 2K. And that's again in St. Pete. My phone number is 727-202-8626. And we'd be happy to help you. Give us a call.
Thank you. I want to thank you for joining us today, Tamara. This is such an important topic for especially for our community, of being able to set things up and get them prepared so that there's not a lot of chaos as we go through, if, at the time of someone's passing, all those things that we want to be able to make sure that our children and our children's children are set for the things that we want to pass down to them. So I really appreciate you joining me today to talk about this topic.
You're welcome. Thank you.
Thank you.